Hey everybody, how's everyone doing? Okay, we got currently 20 participants, so we'll give it a couple of minutes and then get cracking. So, as we kind of get settled, I think maybe get the fingers moving a little bit. It's Thursday afternoon, it's after lunch. So what we'll do, we'll open up the Teams chat, and of the 20 participants, write down or type in 2 words, I'd say, that describes how you feel right now. Whether that's, I don't know, need coffee, ready to learn, currently multitasking, whatever it is, type it in. Then we'll see how everyone's doing. I'll give it a couple of seconds for everyone to wake up and react. Okay, so we've got a few multitasking. Contractually perfect. Define perfect. Subjective. More multitasking. Ian, very disappointed in multitasking. It's Thursday. Let's crack out a bit of positivity. It's all good. Everyone's multitasking. Look at this. Okay, cool. Then one more kind of quick pulse check before we get started. True or false? Contracts and lawyers are inherently boring. True or false? Be honest, I can take it. It's okay. So true or false? Contracts and lawyers are inherently boring. Thanks, Gary. That hurts. It's okay. Partially. Amira, you're supposed to be on my side. Excellent, excellent. So again, to be honest, guys, I don't blame you. But my kind of goal today is hopefully we can change your mind a little bit. Maybe it'll happen, maybe it won't. So before we kind of jump in, a couple of quick housekeeping notes before we get started. So we are going to record the session today, and that's going to be available later on for review for your colleagues, for whoever can't make it, etc. And we can keep it on file and use it again. For those of you who don't know me or we haven't met, so my name is Kyle Wright. I'm the managing partner in Art Consult and Outhouse Legal. Background-wise, I was originally a surveyor. Well, actually, originally I was in the military. I was then a surveyor, and I migrated into the legal field. So I've worked in oil and gas consulting for about 11 years. I've been a lawyer for about 15 years. So again, I spend my days navigating contracts, going through these little areas that you guys will have experienced on a daily basis. So I'm sure I've met a lot of you as well at the IEDC meetings. Right now we have about 27 folk online. So to make sure we cover everything, if you have any questions, stick it in the Teams chat as they come to mind, so you don't forget. We'll have a Q&A session at the end. No doubt there'll be AI questions in there. We'll open up the chat at the end, try and address them. If anything comes up during the presentation and I think we can answer it quickly, I'll jump in. So just before we start then, can everyone see the title slide and hear me clearly? Forgetting the fact that I have an Irish accent. So just drop a quick yes or a thumbs up. Let me know that you can see. Okay, we're good. Perfect. Okay, so yeah, let's get cracking. So today's session, it's a little bit different from the standard contract training. We're not going to focus on what the bad clauses are and the key clauses, etc. We'll cover that in one of the later sessions we'll do on red flags. So today we're just going to focus on, it sounds very elementary, but we're going to look at, how do you read a contract? And that's effectively the skill of navigation. So most people who receive a contract would, that includes experienced operators, etc., procurement folk, HR, etc. People have the tendency to read a contract like a letter, front to back. That sequential way of reading, hoping that some meaning emerges by the time that they reach the end of the letter or the contract. And that approach, as you guys are probably all aware, doesn't really work for a 150-page, drilling contract or subcontract or procurement contract, whatever it may be. And it doesn't work when you have 24 hours to review one as well. So here we'll basically look at a slightly different approach. It's a structured approach, and by the end, you should be able to have a repeatable system for navigating contracts, regardless of its length. At the end, there'll be a little kind of reference card that you can use. So don't worry about taking screenshots and stuff whilst we're doing this. At the end, I'll get the deck shared across everyone who's been able to make it. So again, anything today is general training. This isn't legal advice. Always have to put that caveat in. If you have any specific issues or anything like that, you can by all means contact me directly afterwards. We'll give the email address as well. Okay. So next slide. Let's see. Sorry, my screen is a little bit slower. Okay, so we'll give you a quick overview. We'll start with why structure matters, that mental model shift. Then we'll map the building blocks, what each contract component actually does. Jump onto the third, look at the hierarchy of documents, which is the single most important concept when you have multi-document contracts. We'll jump on to 4 and 5 there, go into a little bit deeper into the two most important reading skills. Understanding definitions and understanding operative clause language. As a lawyer, to be honest, it breaks me. It really hurts with old school legalese where you would get henceforth, notwithstanding one shall. You break into Shakespearean English, which is it's a horrible thing that we do see in older contracts, and you almost have to use the Enigma machine to try and decipher what's being said. The sixth section will cover schedules and boilerplates. Both are routinely underread, in my opinion. And then we have 7, which will be a quick kind of test for you folk to go through it and look at a deliberately problematic extract together. And as I say at the end, we'll give you a quick reference card that you can use as and when needed. Okay, so as I say, jumping in, why structure matters. Okay, so always remembering contracts are engineered documents, and we should look at them that way as well. So let's kind of start with like maybe an analogy we have there on the left on a contract relationship within the oil and gas sector. So a contract is to a legal relationship what a set of engineering drawings is to a structure. So a driller or a well engineer reading a set of well drawings doesn't start with the title block and read the last revision note. What they tend to do is they'll navigate. They'll go to the casing program, the well trajectory, pore pressure, whatever it may be, because they know what they need to know and they know where to find it. So contract readers need exactly that same skill. And the difference is that most people were never really taught to navigate a contract the way engineers were taught to navigate technical drawings. So 150-page drilling contract or subcontract, whatever it is, it's not read front to back in an evening. It's got to be navigated. And you've got to identify the governing or the sections, sorry, that govern the exposure. You read with those exact precise methodologies. You follow every cross-reference to the documents they point to. And that's structural literacy in its simplest way. And this is what we'll try and kind of teach in this this section. So on the right-hand side there, you've got 4 examples. I'm not going to read through it meticulously. You get these 4 examples of what happens when structural literacy is missing. You know, you've got misreading a definition. You know, in a contract, defined terms are usually capitalized for a reason. You know, the contractor group doesn't mean what you might assume. It means exactly what the definition section says it means. And if that definition is narrow, if it excludes your employees, if it excludes subcontractors, then every clause that references contractor group, including the indemnities, the liability cap, the insurance obligations, that will all apply to that narrow universe, which is narrower than what you thought. And then the wrong assumption would then compound through every clause that uses that term. You got missing schedules, you know, the rate schedule, the scope of work exhibits, the technical specs. You know, these are all where the commercial deal actually lives. So many people read the contract body carefully and barely glance at the schedules. You know, in a payment dispute, that's often where, you know, the outcome is essentially determined. Boilerplates, people usually read boilerplates as standard. You know, you've got the governing law, the entire agreement, force majeure, notices. There'll be a lot, I'm sure there'll be questions on force majeure as well. You got notices, you got all these clauses that appear in every contract. So people tend to treat them as identical, whereas the reality is that they're not. Each one will vary, sometimes significantly, and each one can actually determine the results of a major dispute. You got at the end there, you know, document, ignoring the document hierarchy. Say major contracts usually have several documents, general conditions, special conditions, scopes of work, rate schedules, etc., etc. And these documents sometimes contradict each other, especially if they're written at different times by different people and so on. And this hierarchy clause then obviously tells you which prevails. And if you don't find it and you don't know which version of your obligations controls, you're going to end up in a sticky situation. Okay. Okay. So looking at the anatomy of a contract, kind of at a glance, you've got. I would say let's start with maybe the two components that most people would skip, which is usually the cover page and the recitals. And this sounds very, very simplistic, but it's interesting once you actually look into it in a little bit of depth. So your cover page and your parties section, there's 3 things that you should check every single time, and it takes about 90 seconds. And the first is going to be you've got the correct legal entity. The party named in the contract is the only party that you can enforce the rights and obligations against, and the only party that can enforce against you. You can get into affiliate language and so on and so forth later on, but this is the primary point you look at. And you've got to check it's the right company, not a trading name, not a subsidiary, not an affiliate, unless, as I say, there's specific affiliate language agreed. If the contract name's, you know, Drilling Operations Limited, then that's the company you deal with. You know, if you end up dealing with Driller Holdings PLC, you might not be able to then enforce your rights against that party. And this often happens actually in a lot of NDAs, where NDAs don't include the wider group or the allowing of sharing information cross company or intercompany. There's times where you might be employed by X, but the contract is with Y. Theoretically, you shouldn't receive that information. So again, making sure you check against the company's house register, trade licenses, and so on, which usually is done at onboarding anyway, but always double check. You know, the second is then going to be signature authority. Does the person signing the contract have the authority to bind the company? You know, a director has this authority, usually as a matter of statute, especially in the UK under the Companies Act. A company man on the rig, a project manager, country head, regional lead, they may not. So an unauthorized signatory may not bind the company. And that can lead into a whole load of other issues, especially where something goes wrong. You know, if you sign a contract and you're not authorized, there is the potential that your shareholders even could could raise a case against you for fraud. So always make sure that you can sign, that you're allowed to sign, you have the proper authority, and that you have evidence of that authority as well, whether it's a power of attorney, board resolution. What I usually do is if I find that the counterparty doesn't have the documents, I would get a signed and attested letter from their general counsel that the person who they say can sign can actually sign as well. And thirdly there, I'm going to say the effective date. The effective date versus the execution date. These are sometimes different, especially if there's contracts where work's already started before the contract's formally signed and so on. If the effective date is 1 month before you sign, then your obligations and the limitations periods may have started running before you knew the contract existed. So again, check your dates. And if the effective date predates your signature, flag it and then just understand what that actually means for your existing obligations. Recitals. These are the whereas clauses. These are what effectively describes the background context. They are generally not binding under English law. They're mainly telling you the story, setting the scene, and they usually don't impose duties for the parties. But there's one kind of important point with recitals is that English courts use the recitals to resolve any ambiguity in the operative clauses. So later on, if there's a scope of work clause that isn't clear, the recital will go back and describe the party's commercial purpose, what they wanted to do, why they wanted to do it. And then the court may prefer the recital's interpretation of the scope than another area within the contract. Okay. Then we've got 2 practical points on recitals. So if a recital contains a representation, for example, the service provider represents that he has the expertise, equipment, capacity, etc. to perform, check whether that representation is repeated in an operative clause, because if it is, it may be a contractual warranty included in that recital. And if the recital then says that the service provider has a specialist expertise and later fails or falls short of that, it could be argued a breach as well. So again, it's always looking at the devil's in the detail and how things are interlinked, right? And then if a recital describes a commercial context and the operative clause is inconsistent with that context, then it's going to be a drafting error, and then courts would usually resolve that ambiguity in a way that you didn't expect to happen. Okay. Jump to the next slide. Sorry, going a little bit slower. Sorry, my computer's going a little bit slow here. Slide. Yeah, there we go. So can you guys still see the screen? Give me a thumbs up. Yeah. Perfect. Okay. Sorry, I'm working off three screens, and they're not playing ball. Okay. Sorry. What's going? Okay, there we go. Okay, so looking at the building blocks. Again, we've covered the covered parties, we've covered the recitals. Let's look at the hierarchy of documents. You know, when documents would conflict with each other, essentially. So drilling contract or subcontract usually is never a single document. Usually it is it's a bundle. Okay. And with having a bundle, there's going to be multiple aspects we have to cover. So The typical document bundle under like a UK CS drilling contract has the highest priority to the lowest in the pyramid. At the top, you've got the special conditions, and these are the amendments, the additions, the deletions, etc., that are specific to the particulars. This is quite a squished slide, but again, bear with me. You'll get the copy later on. And with all these, the deletions, etc., that are specific, these will override everything below them in the hierarchy. So below that, you've got the general conditions, usually your standard contract terms. In a logic-based contract, the logic general T's and C's are there, and these govern the relationship unless the special conditions would say otherwise. Below that, you've got the scope of work, which is what is to be done. And then specifically in the scope, like an override general language in the conditions on that specific point. Below there, you've got the rate schedule, usually the commercial rates, specific numbers that usually take precedent over the general payment clause language. So again, you're having to cross-reference what does the payment clause say versus what does the rate schedule say. At the bottom there, you've got the technical spec, detailed technical requirements that would supplement and sometimes conflict with any of the conditions above. So the further down you go, the more chance of conflict potentially happening. And there on the left axis, you get the highest to low in order of precedence. And then whenever two documents conflict, the higher one would win. So again, how do you use this practically? Find the order of precedence clause. It's usually at the front or in the general conditions, and it'll say something along the lines of, in the event of conflict, these documents shall take precedence in the following order. Bum, 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 bum. Read it. If it doesn't exist, the UK courts, well, the English courts, I should say, would apply the principle that the more specific provision would prevail over the more general. Okay. And then second, you get special conditions. This is where the commercial negotiation is usually recorded. In a logic contract, there are standard text, usually unchanged from what was published. And then it's the special conditions where the driller would usually delete clauses, amend obligations, add provisions, etc. So read the special conditions first alongside the general conditions, and that will tell you how the contract differs from the standards. Those two will be read hand in hand. Third, then you got schedules. Schedules get equivalent or equal attention to the contract body, and you can't really overstate this. A poorly drafted scope of work could render a well-drafted contract almost useless. And an unsigned schedule of rates, etc., it's just a payment dispute waiting to happen. So check every schedule that's attached, that's specific and unsigned. So whether it's the scope of work, the rate schedule, the technical specs, dig deep into those. And also be careful where things are incorporated by reference. You would see that a lot in like drilling software. Just as an example, any software or any SaaS contract would usually have embedded references. Drilling contracts would also say, the provisions of the main contract apply as so far relevant. And you get into this Russian doll effect of clause and contract and T's and C's inside T's and C's. So make sure where things are incorporated by reference that you understand those references, because otherwise it'll get a little bit tricky. And then here's a worked example just to kind of show you on how you follow every cross-reference, and how every cross-reference can effectively change your understanding, even of a simple obligation, and how reading a single clause in isolation, and it's like you have to review the contract holistically. If you review a clause in isolation, it'll give you an incomplete and often wrong picture. So the obligation that we're tracing here is the driller's payment obligation. Sounds simple. So if you're just this is just a worked example, it's not off an actual contract. If you step one, you find the general conditions clause. There's clause 12.1. The driller shall pay undisputed invoices within the period specified in the special conditions. That sounds straightforward, except the actual payment period isn't here. So you jump down to the special conditions. Special conditions makes an amendment to clause 12. And it says the payment period is 45 days from invoice accepted. Invoice, I know a lot of you will pick up on this. Invoices must comply with Schedule 4. And this is your payment period, but with a condition. And that condition is it's going to be compliant with Schedule 4. So jump across to Schedule 4. That's invoice requirements. So the invoice requirements then set out a mandatory format, required purchase order reference, supporting documentation requirements. So if the service provider's invoice doesn't include these, it's effectively non-compliant. Then a non-compliant invoice doesn't trigger the 45-day payment clock, and it might not even start the clock at all until the defects in the invoicing is cured. This is usually what finance teams become sticklers on. And that's a significant commercial consequence in reality. And that's one consequence buried in, as you see there, 3 different documents. You've got the general conditions, the amendment under the special conditions, and then Schedule 4. So what you then have to do is you got to go back, read 12.4 on the dispute invoices, which is a disputed invoice must be notified within 10 days of receipt with written reason. So the undisputed balance mustn't be paid within the original payment period. So here's now a 10-day dispute window that appears. So if the driller or whoever it is, the contractor doesn't raise an invoice or doesn't raise a dispute, in writing within 10 days, then the invoice will be treated as undisputed. So if you just flip around that, which then means you then have to go back and check clause 12.5 on interest, which says no interest is payable on late payments. And you see how we're getting into this, it's almost like a web. So what seems to be one very simple, straightforward clause, we're now in 5 steps to try and figure it out. So, the picture of the payment obligation spans 5 clauses across 4 documents. And that can only really be understood by following every cross-reference in sequence. And if you read any single clause in isolation, you're going to have that incomplete, potentially misleading picture. And this is cross-referencing discipline. Every time you see it as specified in schedule whatever, or as set out in the special conditions, or as further described, those key triggers that jump out at you, you've got to follow it, because if you don't move, if you don't move until you've closed that loop, you have to get that full circle and full understanding of the clause. So here we'll look at the kind of hidden architecture of a contract. We're on time, so I may take a few questions if we get some. So when we start with the principle, and then show you how the 4 patterns work. So in principle, a contract, every capitalized word has a defined meaning, as I said at the start, and that may differ significantly from its original English meaning. When you read the service provider shall indemnify the driller or the contractor group, the scope of that obligation is entirely determined by the definition of service provider. It's also by the definition of indemnify, and also by the driller group. So none of these words will carry their ordinary meaning. Okay, they will carry the contract's meaning. And if you read the indemnity clause before reading the definition section, you don't actually know what you've read, because you're reading it with your own, human interpretation rather than what the legalistic contract actually says. So the 4 definition patterns that you'll encounter in contracts, and I'm pretty sure we all just say definitions, but there are four main definitions. You've got the narrow definition. So for example, the contractor. So the contractor might mean outhouse services limited only. And that sounds fine at first glance. But then later, when the indemnity says the contractor shall indemnify the driller against claims by the contractor group employees and the contractor group, where the contractor group's defined as just a company, then your employees are not in your group. So they're not protected by the indemnities. And that could then bring claims later on against the driller or the contractor that the indemnity doesn't cover. And it's a very simple but very common and very costly drafting gap, making sure you know exactly who's included. You could have the broad definition where the contractor group means the contractor, its parents, subsidiaries, affiliates, officers, employees, the subcontractors, agents, and their respective personnel. And that's what a well-drafted definition looks like. You know, everyone relevant to the operations is inside the group, and the indemnity then protects all of them. And then you've got the circular or the catch-all definition, which means the services described in scope of work, such all other services as a driller may require. That definition looks it looks like a reference to a specific document, but the catch-all tail that's there and such other services as a driller may require creates this open-ended obligation inside the definition itself. So the scope of services expands with every instruction. And this is like a catch-all trap that gets hidden inside definition. So always keep a wee eye out for that, depending on which side you're on. And then you got the incorporation by reference. So the main contract means the drilling contract between the operator and the drilling contractor as amended from time to time. And this definition imports imports an entire document, as amended from time to time. And that means the content of this definition changes every time the main contract's amended. And that could be potentially without notice to the service provider. So this becomes like this definition by reference is then a moving target. You got to make sure you don't fall trap to. Okay. And you got the 7 definitions that you should read first. Every oil field contract, subcontract, if you read nothing else in the definitions section, read these 7 if you want to ignore everything else. So the first is the contractor group or the service provider group. Okay, this is who's protected by the indemnity regime, and it has to include the service provider entity, its parents, affiliates, employees, officers, subcontractors, whatever you can. And the watch here is that if it's defined as the company alone without employees or subcontractors, the mutual hold harmless protection might not cover your people. Yeah. Second would be then the driller group or the operator group. Who you're indemnifying, who's indemnifies you. In the drilling contract or subcontractor, this is typically the driller, its affiliates, the well operator, potentially the entire operator group, and so on as well. And a very broad driller group definition means that you're indemnifying a large number of entities for a wide range of potential claims. So it's really important that you know the breadth of who you're actually indemnifying, and that obviously would tie in with your insurance clauses and so on as well. Thirdly, you've got the service and scope of services. This is the operative definition of what you're contracted to do. It must be it has to specify all activities required to complete the well program as directed. If you have an unlimited scope and it's written into the definition, you have to flag it. You should always make sure you know exactly what you're doing. It's not open-ended, and you know where the exits are. The fourth thing, you got consequential loss, and this categorizes this is the category of loss which you excluded from liability. Standard inclusions of like loss of production, loss of profit, loss of use, reservoir damage, and all that would be in there. So if that definition is narrow or narrower, I should say, than the main contract, then there's going to be a gap and you got to do a gap analysis. because then service provider breach causes drillers loss, and the loss isn't excluded under the subcontract, then the service provider is going to be the one who absorbs it. So again, making sure you cover yourselves. A great one is the gross negligence and willful misconduct. That'll usually either be in the definitions or embedded in the indemnity and liability clauses. And this is usually a carve out from the mutual hold harmless regime. And it should require a high threshold, which is usually recklessness, conscious disregard for consequence and so on, just doing it without caring, essentially. And it's defined to capture anything beyond minor carelessness. And the carve out becomes a trap. So make sure you read the definition and not just the carve out. Sixth there, we got force majeure. What circumstances excuse non-performance? You got to check specifically what it covers. Does it cover adverse weather in your operating field? Does it cover regulatory shutdown if it's of the specific field? Does it cover pandemic type restrictions? Each event excluded from a force majeure is a risk that you guys would carry. And always remember the threshold. My honest opinion is that force majeure clauses are a misnomer. The threshold for force majeure is extremely high. I remember once we had there was a fire in a factory in Chile which was a subcontractor's factory. They claimed force majeure because fire was mentioned in the clause, but ultimately whether or not it was foreseeable or not was one of the questions. And it was foreseeable, because it would be foreseeable that a fire would occur if you neglect your annual maintenance of your panel board in your electrical cupboard. And that's what the cause was there was lack of maintenance, which then caused the fire. So it was reasonable to foresee that a fire would be caused by poor maintenance. So it wasn't a force majeure event. So things like that kind of consider. And also it's got to render things impossible as well. So you got to again look at that with a broad lens of, is the contract frustrated? Are the services frustrated? Is it virtually impossible? It's got nothing to do with economics, whether it gets more expensive. You could try and argue that, but again, whether or not there's an alternative route for delivery, etc., as we saw recently. And seventh there, so we digress. Seventh, you've got the affiliate company group. So this determines the scope of both the group definitions. So if the affiliate requires 50% plus ownership and a 49% shareholder falls outside that group, then check the threshold against your actual corporate structure with your corporate governance teams. Okay. Here we'll jump into the operative clause, or the operative core. So we're going to look at the obligations, conditions, and consequence. So every operative clause, however long or complex, does three things. It identifies who has the obligation, it states what the obligation is, and it specifies what happens if it's not met, the consequence. So three components: the obligation holder, the obligation, and the consequence. So the obligation holder, so the subject of the clause, the example here, the service provider shall. So here the service provider is the obligation holder. If the service provider fails, then the service provider is liable. But note though that some clauses are poorly drafted and the obligation holder is unclear. An example, it is agreed that invoices shall be submitted monthly. Okay, who exactly must do this? It's ambiguous drafting, and ambiguous drafting is what creates disputes. The obligation, the substance of what must be done, and that leads to several sub questions. Is the standard objective fit for purpose? In compliance with HSE manuals, or is it subjective to the driller's reasonable satisfaction? So those are two very different tests. And it's, you got to ask the question, is it a best efforts obligation or is it an absolute obligation? Is it time bound? Shall mobilize by whatever date versus shall mobilize as soon as reasonably practicable. what triggers the obligation? These questions are, with lawyers, you ask a lawyer one question, you'll get 10 questions back. That's usually how it works. Or if you ask 10 lawyers, one question, you'll get 15 different answers. So these questions of every operative, you have to ask these questions of every operative clause to give you that full picture of exactly what you're agreeing to. Okay, so you know your obligations. And then you got the consequence, which is obviously it's what happens if the obligation is not satisfied. Okay, so is that a termination right? Is it the payment of liquidated damages? Is it an indemnity obligation? Is it a step-in right? And a lot of these clauses will state the obligation and are entirely silent on the consequence. So in those kind of cases, it would be like a general breach and a remedies provision of the contract that would usually apply. There's a right to damages. It could be potentially termination for repudiatory breach. So always be aware then that essentially silence on consequence isn't safety. It's uncertainty, because again, you could be left at law on those decisions through disputes, and it's that uncertainty that racks up some hefty bills, whether it's time, damages, etc. Okay. So jump in on the obligations. So this slide's one of the most kind of practicable, useful slides, I would say, in the session. So you'll have it at the end once we share it in the reference card. So the words used to express an obligation basically determines how hard it is to satisfy. So whether you can be held in breach, it's just as an example. So under English law, these words have specific legal meaning. In different jurisdictions will have potentially different meanings, or they won't differentiate between the two. But for all intents and purposes, we'll use English law to give you that vision. So shall is mandatory and absolute. So this creates a binding obligation with no discretion. You shall do that. The service provider shall mobilize by the 15th of March. So failure on that date for any reason, whatever it is a breach. So the word shall carries no excuse provision. Then you go to must, and this is the functional equivalent to shall in English back-to-back contracts. So this is quite common in HSE and compliance clauses. The personnel must complete all rig inductions before commencing operations. Same consequence, breach is liability. You must do it. It's mandatory. Shall use best endeavors. Here you kind of get into Shakespearean English again. This is I'd say a significant step down from shall. It's not a weak obligation, but under English law, the best endeavors requires doing something reasonably possible to achieve the outcome. So that includes at some financial cost to yourself. It falls short of this absolute obligation. There are going to be limits to it, but again, if the bar is high, then it could be an issue. And yes, it's not the same as a reasonable endeavor. So be careful not to use those interchangeably. Yeah, don't put words in where they don't exist. And that leads us then to this, shall use reasonable endeavors. This is, again, a lower standard, and it requires that balanced, proportionate effort. Not everything's possible at any cost. And obviously, you have to have that defensible position to show that it's not possible for the economic improportionality. And it's context dependent. If both parties have competing obligations, reasonable endeavors doesn't require the contractor to satisfy those other obligations to satisfy this one. So just be again cautious of that. Will, very ambiguous. Will can express a promise that's binding. It can be an intention, which is non-binding. And courts will interpret this contextually, and again, looking at what the recitals have, how the recitals bring in context. So in contract drafting, try and go for shall for obligations. And then when you see will in a contract, kind of ask the question, is this intended to be binding? If so, it should say shall. And you can't even, people sometimes get into the semantics of it, arguing it, but again, you can use this as the guideline. And then you have may. May is discretionary. It grants this power or right. It's not an obligation. So the driller may inspect the service provider's equipment on arrival. The driller can do this if he wants. He doesn't necessarily have to. It's discretionary. So if there's a failure on that, then there's no breach because there's no breach for failing to exercise a may right. And then we have should. You know, it's generally non-binding. It's an expectation or recommendation. As I say there, it's an aspiration, and it's rarely appropriate in operative clauses. So if something should be done, again, the contract should say shall. So just be aware of those little words that may trip you up when you review. So conditions. So let's get a little drink here. With conditions, the parts of the contract that govern when obligations arise or fall away. Understanding the conditions prevents two common mistakes. The first is going to be, so for example, claiming payment before the triggers not be met, or missing a trigger that extinguishes your right that you thought you had. So within this, you got three buckets. You got the conditions precedent, which is the condition that must be satisfied before the obligation arises. The insurance certificate, as an example there, the insurance certificate must be delivered before mobilization starts. So mobilization cannot start or cannot proceed until the certificate's provided. And an invoice must comply with Schedule 4 before payment, payment clock runs or whatever. So you consider those details. The practical consequence of this is that if the condition precedent isn't satisfied, the obligation doesn't arise. So if the obligation is the driller's obligation to pay, and you haven't satisfied the invoice format requirements of Schedule 4, then your right to payment hasn't been triggered yet. So, and this is how many payment disputes begin or start. So the service provider submits a non-compliant invoice, assumes the 45-day clock has started, and then escalates whenever the payment doesn't arrive within the time frame, not realizing that the clock never started. So check before you submit the invoice that you've satisfied all the conditions precedent to payment. Obviously, it's going to affect your cash flow as well. You got conditions subsequent, which is a condition whose occurrence terminates an obligation already in force. So the operator withdraws the well program, the drilling subcontract terminates, a regulator approval cannot be obtained, and then the specific elements of the scope fall away. So the contract was in full force. The condition ends it. So the kind of watch out here is, does the termination of the obligation extinguish rights that had already been accrued? For example, payment for work already done. So under English law, the accrued rights usually survive, which you will have your survival clause in the contract, or you should, usually survive unless the contract expressly extinguishes them. Okay. And then we have concurrent conditions. Both parties' obligations arise simultaneously, and neither must perform first. This is quite common in milestone-based contracts, where the service provider would deliver the completed service, and the driller's payment obligation arises at the same moment. So neither is required to go first. If either fails to perform, then the other is discharged. So drillers, withholding payment entirely because of a minor defect in performance may itself be a breach, if the services have been substantially performed. And then you get into the definition of what does substantially mean, and so on and so on and so on. So it's making sure the drafting is correct and your understanding of the drafting is correct as well. To jump in here to schedules, exhibits, and so on, and this is then, you could argue it's the, as I said at the top, the commercial heart of the contract. So we look here, a well-negotiated set of operative clauses with a poorly drafted schedule is still a poorly negotiated contract. The schedule is where the deal actually is. So have a quick look in each of these schedule types, which again I'm sure you're all aware of, but looking at it with a different lens. Now, so you got 5 things that should be included. You're going to have scope of work. You're going to have the specific well, the field, the location. So that the scope's geographically bound. You got named services with precise technical descriptions. You're not gonna, not wireline services, but you have your production logging, casing inspection, cement bound log on well X, whatever it may be. You're gonna have defined deliverables, and what constitutes completion. You're gonna have the acceptance criteria, things that are deemed within the acceptance period. And if the driller doesn't respond within 10 days, the deliverable is accepted, etc. And what is actually excluded from the scope? What we usually find is people get lazy on the scope of work. People would draft the scope of work on their own knowledge rather than the view of if they disappeared the next day and somebody else had to pick up that scope of work, could they read it and understand it and know exactly what has to be done? So this is very generally underused as far as acceptance certificates, etc. We're going to make sure that everyone's aware of what the scope is, know what you're paying for, know what you're meant to be doing, know what's included, because then obviously that could lead to scope creep. And as well, if something's explicitly excluded, if it's not in, it's out, is where we kind of look at these things, and try and prevent those kind of catch-all arguments later on. And the risk is generally that if the schedule's vague, the contractor shall perform all cementing services as directed by the driller. That's pretty lame. And if that's in the operative clauses, that will become an ultimate or unlimited obligation. So the scope of work schedule is like your only defense against that scope creep. You got to make sure everything is, you're saying what you want and you're getting what you want. You got the schedule of rates, or the rate schedule, which must cover basically all scenarios: operating rate, standby rate, something's broken down by cause, waiting on driller, waiting on weather, equipment breakdown, wait time, zero rate scenarios. It can be quite extensive. A cancelled mobilization fee, and if applicable, you would have a variation pricing formula, etc., in there for additional services, or anything like commoditized rate fluctuations or exchange rates as well. And an unsigned rate schedule, usually they get signed specifically or at least initialed. If it's unsigned or it's one that doesn't address all these scenarios, it's just this mass dispute register waiting to be opened. So both parties need to make sure that they've seen it, they've read it, they've understood it, initialed it specifically, and it's not just the contract body. Key personnel is another important one. You could have named individuals, their roles, minimum qualifications, the replacement process. How does a driller approve the replacements? How quickly? What's the criteria? Who pays for the mob and demob costs on replacement? And if the schedule has names but no process, then it's another operational trap that you got to make sure you can get yourself out of. Then you got the insurance schedule, which is probably one of the most under-checked exhibits in oil field contracts. Obviously, it covers the minimum limits per policy type. It's got additional insured requirements, waiver of subrogation, cancellation notices, and so on, and how the evidence of the cover must be provided. Check the schedule against your actual policy as well. Usually within, for us, the treasurer usually holds the insurance documents, but check it with the policy before you sign, because check every item, because the mismatch between the schedule and what your actual company policy has is going to provide this uninsured exposure area, which you don't want to be in that position where you think you're covered, but you're actually not. Right. Aware of time here, got a few more slides to go. So here we got the boilerplates, and to say this clearly, a boilerplate is not standard. It's called standard boilerplate or standard because it appears in every contract, not because it's identical between each contract or it's unimportant. Every clause that I've got here on this this slide, it'll vary sometimes sometimes significantly between the contracts. So every one of them can determine the outcome of a dispute. So just to cover the kind of 6 biggies quickly, you got the entire agreement states that, well, the written contract is the complete agreement. Pre-contract representations, verbal assurances, email threads, blah, 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 from the negotiations are excluded. Once signed, that reassurance is for you and your company or your companyman to give the legal worthless or the word not worthless is the wrong word, the legal value in it. Anything that happened before that on the phone is pointless. It doesn't mean anything. Gentlemen's agreements are going to be virtually worthless. So everything must be in the written document. If something was agreed before signing and it isn't in the contract, add it into the special conditions or the schedule amendments before you sign, or have a written amendment later on. Again, force majeure, 2 components, the events listed and the procedure for claiming it. Again, the event, does the clause cover the weather conditions in your specific operating area? Because a storm in the Gulf of Mexico and a sea state force 8 or whatever in northern North Sea are different risks. So does it cover regulatory shutdown of a specific field? Government travel restrictions that prevent the personnel from mobilizing. And the critical point is, force majeure, as I say, it's not self-executing. Most clauses require notification within 24 hours or 48 hours of the event beginning. So if you miss that window, then you may lose that defense. And as I said earlier, the threshold for that defense is extremely high to prove. Governing law and jurisdiction, which legal system governs and where are the disputes resolved? Usually in the UKCS, it's going to be English law, English courts, London arbitration. The 2 things to check would be, is this consistent with your main contract? If you're the driller, and if your main contract is English law, but your subcontract is, for example, Scottish law, any disputes touching both levels will have a degree of legal complexity within it. And if it's arbitration, I'm a chartered arbitrator, so I've been involved in a lot of ICC arbitrations. And you do see this a lot, is what seat, what rules, what language, and is the form practical for the contract value. So like an ICC arbitration clause in a £50,000 services subcontract is massively disproportionate, because just the fees to file and apply for the arbitration will be significantly higher. So again, it's horses for courses. They got variation and amendment. It sets the rules for how the contract can be changed. Usually requires a signed written amendment from an authorized representative. And this is the clause that makes verbal instructions in the disputes, as a gentleman's agreements. Know who on both sides has the authority to sign that valid variation order or change order. And an instruction from a companyman on the rig might not bind the driller unless that person is expressly authorized. So make sure it all ties together. And notices, second last, every formal notice, whether it's termination, force majeure declaration, disputed invoices, a claim notification, has to be served in accordance with the notices clause. So know what you have to do, the correct method, the correct address, the correct deemed receipt period. Whether emails are acceptable, faxes, I don't know who uses faxes anymore. An email to a personal address when the clause requires services to a registered office might not constitute a valid notice. You would obviously look at the substance over the form eventually in a dispute, but you don't want to have this convoluted way of getting to prove your point. Again, a notice sent by post may be deemed received 5 days later, even if the physical is received sooner. So again, this will then have a knock-on effect on your cure periods, your limitation periods, and your deadlines. And then we got finally waivers, which that prevents that pattern of conduct from creating a permanent entitlement. So a driller pays a non-compliant invoice twice. and they say, oh, well, you paid it before. The waiver clause means it doesn't actually require them to accept non-compliant invoices in the future. So the service provider accepts a late payment without protest. The waiver clause means that they haven't permanently waived their right to insist on that timely payment in future. So both parties should understand this, that the commercial tolerance during operations doesn't create contractual rights. Okay. And let me go to the next. We're almost there. So before we do the exercise, we're a little bit over time, but we'll spend about 5-10 minutes on this. Before we do the exercise, I want to give you guys this navigation framework as a repeatable system. So there's 5 phases, and the total phase usually is about 17-ish minutes for an experienced reader. In fact, you know what I'll do? I'll go through the structure. I won't actually do, because of time, I won't do the example, and I'll let you guys do that in your own time. If you have any questions, you can email me after. So this is not going to be like a full legal review. It's like a triage that gives you the information that you need to know and what questions to ask and where the risk sits. So phase 1, as with any kind of map reading, as an example, orientate the map. This takes about 2 minutes. Check the cover, check the parties, the effective date, the governing law, find the table of contents or the document schedule. Count how many documents make up the contract, find and read the order of precedence clause. And these 2 minutes basically set up everything else that follows. Phase 2 is to define. Take about 5 minutes. Read the 7 critical definitions. Flag any definition that is either narrow or circular or incorporates documents by reference. So not every capitalized term used in the operative clauses you're about to read. Make sure you know what each one means before you read the clause. Okay. Thirdly, there you've got map obligations. So take 5 minutes. Identify the 5 high-risk operative sections: scope, payment, liability and indemnity, insurance, termination. And for each of those, ask the question, who's the obligation holder? What's the standard? Is it shall? Is it best endeavors? Is it reasonable endeavors? What's the consequence? And so whenever we kind of draft clauses, it's like an algorithm. If so, then what? And you kind of tree diagram that out. And then you follow every clause or every cross-reference before moving on. Then we got 4th, check the schedules. Take about 3 minutes just to read through the scope of work, whether it's specific or is it catch-all, is there anything you see missing when you run through the operations in your head. Is that how you would do it? Is there something that's not being done? Is there a critical gap? Look at the rate schedule. Does it cover all scenarios? Is it signed? Look at the insurance schedule. Do the insurance requirements and require limits match the policies that you have available? Are you going to have to get an extension, etc.? And check the document hierarchy. Check that it includes the schedules. Okay. And then finally there, you've got read the boilerplates. Take 2 minutes. What is the entire agreement we've just mentioned? What does it include? Force majeure, what's the procedure? What events are covered? Notices, is that the correct address? What is the method? Familiarize yourself, because you're going to be the one who's operating the contract. And then variations, what makes a valid instruction? So you're going to talk about 17 minutes. It won't tell you everything, but at least it'll tell you what you don't know and where to look next. Okay. But then the navigation exercise, I will send this to everyone after. I don't think we would really have time to kind of go through this, to be fair. And here then we got the quick reference. So this is your takeaway for the session. The contract navigator's pocket guide almost. It's got 4 quadrants: orient, define, map, obligations, and check the schedules. We've just run through those. You've got basically there 24 checkpoints. Most could be completed in 15 to 20 minutes if you've practiced the approach a few times. Pin it next to your desk. Use it in your next contract that you receive. And as you go through it, point note just how this complements the red flag training that we're going to have later on. We'll have extra training. Use this quick reference card to navigate. Use it to check what you're looking for, what are the high risk sections, and use this holistically with your own knowledge. Use your legal team, and create this kind of complete contracts review system. So one structure with a lot of substance in it that will make reviewing a contract a lot quicker for you. And then we got the key takeaways here. So if there's anything I want you guys to take away from this session, it's these 6. So shorten the session because you've already done the work, So no, don't read the contract like a letter. Navigate it, orientate, define, map obligations, check schedules, read boilerplates, structure before substance. Read the definitions before the clauses. Every capitalized word has a precise meaning. Okay, the wrong definition assumption compounds through every clause going forward. Find the order of precedence, clause. Whenever a document conflicts, which they frequently do, the hierarchy clause tells you which wins. So no hierarchy clause, then the more specific provision prevails. Schedules, schedules aren't for decoration. Simply, scopes of work, rate schedules, insurance schedules, these contain the commercial deal. So a well-drafted contract body with a poorly drafted schedule is still a bad contract. Boilerplates, as I say, they're not standard. Look at the entire agreement, FM, variations, etc., because these will differ between contracts. So read them every time. And then 6, follow every cross-reference, because a clause that sends you to the special conditions, which one sends you to a schedule, which incorporates a third document. Do you have that third document? The full obligation only emerges at the end of that chain. To make sure you follow that chain, follow that cycle. And never read the clauses in isolation. Okay. So we'll have a quick few minutes on kind of Q&A. I haven't been able to see the chat box here whilst presenting. But again, as I said earlier at the start, this is general training under English law principles. It's not going to be specific advice for your specific contracts. You can contact us after for that if you have any specific questions. Yep, so what I'll do, I will stop sharing the screen. You can jump in to see if we have any questions or not. Might have presenter mode. There we go. We got any questions in the chat? Do we have anything? Don't be afraid to ask any questions. I also see it appears that most people have their cameras off as well. Nope, no questions. Perfect. Okay, so as I say, if anyone has no question, but very helpful. Thank you, Gary. Again, it's for me, it kind of shows with contracts, people tend to be quite blasé about them. I know that with the dawn of AI and the ability to use GPT, etc., in contracts is very, very tempting. But we always have to remember the Mark 1 eyeball, human judgment and experience is something that would usually massively prevail over these things. So again, always ask if you don't know the answer, and check with your legal team, check with myself if necessary. I've just realized there that I closed the PowerPoint, but we can share my email address, etc., and everything afterwards as well if you have any questions or you have any concerns specific to any of the contracts that you're working on. And yeah, cool. So with that, we shall end the session, and hopefully I'll see some of you guys if you're going to go to Qatar for the next IDC meetup. Hopefully I'll be there as well, and we should have another session. I think the end of next month. So probably for the next 3 months, we'll do a session. The next one I think is going to be on key risks. There's going to be another one on potentially force majeure. I think there's 3 or 4 lined up. But if there's any topics, because we're choosing the topics from a survey we did last year, We reached out to everyone, did a survey, and said, hey, look, which topics are the ones you want to see, or which topics are your major areas of concern. So if you have any more stuff, drop a message if there's anything that you want to see. We can definitely look into it, or have a one-to-one session if it's something specific to you as well. Okay, so perfect. Thanks, guys. Appreciate it, and we will keep in touch. Okay, thanks, everyone.